City Attorney?
Well, look how much time I have left to talk. I wanted to give a brief update of the status of the appeals of the code enforcement cases regarding our sign code. We have a date with the court beginning of first week in March, in which I'm going to hope that the judge will establish a deadline for the appellants to file their initial brief, which is long overdue for certain reasons that may be somewhat justified. And my next comments, I don't anticipate any sympathy, but my firm was on a firm planning retreat this past weekend in Colorado, and my skiing days are long past. So I used the time in my hotel room to go through a stack of U.S. Supreme Court decisions twice the size of today's agenda packet, and to brief them in preparation for the brief that I'm going to need to write in response to the initial brief. And I just want to let you know that if in reviewing the legal arguments that are made by the appellants in that case, or upon my review of any additional case law that as part of my research, if there's any reason for us to take a different course with respect to our current ordinance, I will bring that to your attention and make sure that we take the appropriate action. But as of today, and all of the cases that I had the opportunity to review over the weekend, I still feel confident that our approach in our ordinance is legally correct. There's a lot of nuances in many of the cases that people cite to be able to use the F word, for example, as protected freedom of speech. It just doesn't apply to the way that we have identified the various terms in our ordinance, and feel very comfortable still that our ordinance will withstand the challenge. So, but if there's a change, I will certainly let you know. Thank you.
Okay, thank you. Do we have any updates on Shoreline?